On this morning's docket. That is case number 101054, State of Kansas v. John Henry Horton.
Good morning, Your Honors. May it please the Court. Lydia Krebs of the Kansas Appellate Defender Office for the appellant, Mr. Horton. And if I may, Your Honor, I would like to request 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. As this court knows, this case is again before the court on the very limited question of whether the district court erred in determining that it should not have and would not have reopened evidence upon defense counsel's motion that it do so. While this court does review a district court's decision on a motion to reopen for an abuse of discretion, that standard of review is affected by a district court's failure to apply the appropriate legal standard. That is, a district court, by definition, abuses its discretion when it makes an error of law. And here Mr. Horton argues that that's what the district court did in misapplying the Murdoch factors. Before I address those legal errors, however, I would like to point out that the state has failed in either of its briefs to address the question of whether, if error did occur, that error was harmless beyond a reasonable doubt. And it's the party benefiting from that error, it's the state's burden to prove beyond a reasonable doubt that there's no reasonable possibility the district court's error affected the verdict.
How do we square that with the legislative direction that we cannot set aside a verdict without a harmless error determination on our part?
I'm not sure I understand how those are contradictory. That this court can't set aside a verdict unless if there's no problem with the substantial justice.
Does that? Well, no. We are directed to do a harmless error inquiry by a separate statute, and does that mean that we have to fill a void if the parties leave us with no argument?
I suppose if the parties left this court with no argument, the court might still have to, would probably still have to apply that harmless error test and make that determination. But whereas here we have one party making that argument in a brief and the state has failed to respond, failure to brief an issue waives it. So I would say the state has waived any opportunity to make that argument before the court today. The district court did abuse its discretion on remand here in failing to properly apply the Murdoch factors.
And how did I understand your argument in your brief, but could you again state how it abused it? It didn't apply the proper discretion, that it abused its discretion in not applying the factors?
Absolutely. So
it just seems to me that the trial court, in its order, pretty much jumped through all the hoops of each of the Murdoch factors, looked at the Murdoch factors, weighed them, and made his decision that I would not have reopened the case. And I'm confused as to how that is an abuse of discretion.
the problem here is that the district court, while it applied all of the factors, it blurred the lines between the factors and conflated them, essentially. So in setting forth the Murdoch factors, this court relied on Blankenship, which in turn quoted to Larson. And in that case, the Larson court applied those three factors very separately, discreetly, and orderly, rather than blurring the lines between them. So in analyzing the timeliness of the motion, the Larson court made clear that that factor deals with whether the party moving to reopen evidence has advanced a reasonable explanation for its failure to present that evidence in its case in chief. In analyzing the character of the evidence, the district court should only ask whether the evidence is relevant, admissible, technically adequate, and whether it would assist the jury in determining the defendant's guilt. And then only during that analysis of the third factor should the district court consider whether the timing of the admission of the evidence would imbue it with distorted importance. And here the district court repeatedly blurred those lines by considering factors only relevant to the third inquiry, the third factor, in considering both the second and first factors. And that allowed the district court to overemphasize the weight of the third factor, which it found weighed against Mr. Horton, while minimizing the importance of the first two factors, which it should have found weighed in favor of Mr. Horton. So that was the district court's error. That although it gave lip service to analyzing the factors, it didn't analyze them appropriately. So instead of concluding that the district court made a finding that defense counsel's explanation for not presenting this evidence in its case in chief was reasonable. It made that factual finding that it had a reasonable excuse for not presenting the evidence in its case in chief. So it should have found that that first factor weighed in favor of Mr. Horton. But instead of doing that, the district court analyzed the factor and concluded that the prejudicial effect of reopening the evidence would have given that evidence undue weight for the jury. That was a factor that the district court should have only considered in analyzing the third factor, not the first factor. It did the same thing with the second factor, where instead of asking simply whether that evidence was relevant and admissible and technically adequate, and whether it would assist the jury in determining the defendant's guilt, the district court instead again blurred the lines and concluded that the evidence wouldn't have been helpful to the jury because of the distorted importance the jury would place on it. So essentially the district court said that the problem was not that the evidence would not be helpful to the jury in determining Mr. Horton's guilt, but that it would be too helpful, that the jury would give it too much weight based simply on the timing of its admission. And again, that's a finding that the district court should have reserved for its analysis of the third Murdaugh factor, not the second one. Moreover, that finding that the jury would have given the evidence so much weight that it would have prejudiced the state seems at odds with the district court's other finding that no reasonable juror would have reached a different conclusion based on that testimony. So no reasonable juror would have reached a different conclusion about Castillo-Contreras' credibility based on that evidence. But if the evidence wouldn't have been sufficient to play a role in any reasonable juror's decision, then it's difficult to understand how it could unfairly prejudice the state. Finally, in addition to blurring the lines between the factors, the district court also abused its discretion in misapplying the third Murdaugh factor in a few other ways. First, as I just noted, the district court's findings seem to be inherently contradictory. The district court can't have it both ways. Either the admission of the evidence would have been helpful to the jury in determining Mr. Horton's guilt, in which the district court should have found that the second factor weighed in favor of Mr. Horton, or the evidence could not have possibly convinced a rational fact finder that Castillo-Contreras was not a credible witness, in which case it's hard to understand how the third factor would weigh against Mr. Horton.
Wasn't the charge to the district court to go back to where you were as when this request was made to stop the deliberations and apply your discretion? The trial court didn't have to do anything more than that, didn't have to get the transcript from the interactions between the witness and his mother, didn't have to do anything but just apply. It seems to me the trial court went above and beyond what the charge was, got this information, and I think everybody was wondering, probably at least the defendant, the court, and maybe us, is there some sort of smoking gun? Is there something that would absolutely exonerate Mr. Horton or that didn't exist? But again, the task was to apply your discretion as it was at the time this request was made. And isn't that what the court did?
Well, it abused that discretion because it didn't appropriately apply the correct legal framework. So while its actions in admitting that evidence may have been admirable, that doesn't excuse its failure to appropriately apply the Murdaugh factors. And this court did explicitly say in its opinion that the district court could consider.
Yes, may consider.
Right, may consider. And so if I'm the district court, I'm going to say, well, if the Supreme Court says I may consider that, I probably ought to, just to be thorough. So, but I'm not still.
It just seems to me that's what the trial court did. The trial court did consider the evidence, did a weighing factor, applied all the Murdaugh factors, and concluded that no, I wouldn't have allowed this to occur. Especially, and again, I didn't have this information, knowing that it would take at a minimum 60 days to get this information. And you're going like this, waving your hand for. That's what the record indicates. How could a trial court suspend deliberations for 60 days, and then have a jury come back, have the admonition in place, and go ahead and start up deliberations? I just don't know how that would work in light of what this evidence is.
I have a couple of problems with not necessarily the finding that it would have taken 60 days to complete a certified. Right, I'm not disputing that.
Pretty much what the evidence was, that this was very difficult. It took for every minute of interaction, it took an hour or something. I can't remember the exact ratio, but it was an incredible amount of time it took this transcriptionist to decipher what was happening, and then. Once it's deciphered, I've read this 3 or 4 times, the interactions. It's almost nonsensical.
So, yes, it would have taken 60 days to complete a certified translation of every single conversation. But in 2 days, it sounds to me from the record like she had done a cursory, not a certified translation, but a loose translation of almost all of it. In fact, it sounds like she finished that loose translation almost immediately after the jury started deliberating and immediately went to defense counsel. So the 2 days would have been enough for defense counsel to review that cursory translation and then pick the relevant portions of the transcript. As Your Honor can see, I've only cited to, I think, maybe 8 or 9 places in the transcript that were relevant to have those portions certified. There's no evidence that that would have taken 60 days to have the relevant portions transcribed.
And given those relevant portions, what did you have? You really didn't have anything that was going to add anything to the case.
I would absolutely.
In the judge's mind, who's heard and now for the second time presided over the evidence in this case.
I would absolutely disagree with that. I would state that the recorded transcripts of the telephone calls reflect contradictions between what Mr. Castillo-Contreras said on the stand, which was, I'm only doing this out of the goodness of my heart, that...
I understand all that, but there was evidence that there was evidence by 2 other defense witnesses that said he had a deal, that said he was doing this for deportation, that said he got a letter to the, I think it was the Colorado Department of Corrections. The jury knew all that.
All he got was a favorable letter to the parole board. There wasn't anything that I can find about his statement that he would not testify unless he was going to be deported. That's what he said on the phone calls. And the state argues that this impeachment testimony came in through the other witnesses that the defense called, but the state doesn't point to any statements in its brief that were made that impeached his credibility. And in fact, if this
Is the biggest fact that impeaches his credibility that he read the first case before he even came forward with any of this information? Don't you think that's the biggest piece of it? And that was before the jury through several witnesses.
I think that that's helpful, but it doesn't prove that he's a liar. The evidence that came in through that would have come in through the telephone conversations showed that he's willing to lie under oath to the court, and I think that's huge. Those witnesses that the state argues defense counsel offered to impeach, in actuality, Budenhagen testified that he couldn't say whether Castillo-Contreras had a reputation for truthfulness. That's record volume 44 at page 124. Bradford testified that he was known to be a very truthful person. So this is the impeachment testimony that the state has pointed to. And then Cowan gave no opinion at all on his credibility. So to say that he was properly impeached through these other witnesses is simply not borne out in the record.
Counsel, I see you're out of time. Would you like 30 seconds to sum up?
Your Honors, I would just respectfully argue that the district court repeatedly made errors of law in applying the Murdaugh factors, therefore abusing its discretion, and that because the state can't prove that harmless beyond a reasonable doubt, this court must reverse Mr. Horton's conviction. Thank you.
Do we have any further questions? Thank you, counsel.
Thank you, Your Honor.
Good morning. The court highlighted some of the factors that we feel are extremely important and indicate that the district court made the proper findings of fact and law in their determination that there was no reasonable grounds to reopen the case after the jury had been deliberating and the information had been provided to the court. We're going to stay on the narrow focus of what this court asked us to do, which is review the evidence that was presented in our further hearings and make a determination of whether or not, based on that evidence that was presented, whether there was sufficient grounds to reopen the matter. The district court gave great deference to all the parties to present any and all evidence that he felt was necessary to flush all this out. We had substantial hearings and evidence that was presented on this matter, and then the district court made, I think, a very thorough finding He used and applied Murdoch, which I think everyone agrees is the proper analysis to make. And in Murdoch, it set forth the factors the court is to apply. The court did that in its written memorandum, and I believe it was a proper analysis of those factors.
Mr. Howe?
Yes.
Excuse me, what about your opponent's point that the judge may have conflated somehow the factors under Murdoch?
Well,
What's your response?
well under Murdoch,
Excuse me.
it didn't really say what was the way that you were supposed to use those factors. It just set forth the factors the court is supposed to use. And I don't think, you know, in each of those elements, the timeliness, the effect, I don't think you apply that in a vacuum where you just have that one factor without applying some of the other factors and how that they all meld together, I think. And the court, I think, highlighted that in its analysis, is that when you talk about the effect of that evidence, and if you had granted the motion, I think you have to talk about all those other things. And so I think the important aspect is Judge Davis applied all of the criteria set forth in Murdoch in his decision. We may all agree or disagree on the way he applied it, but I think his analysis was consistent with what Murdoch asked the courts to do. And I think when you look at the one thing that I think is very compelling is if you look at the brief by the defendant, they cite a lot of cases, but not one case can be cited where a jury has begun its deliberations and a court has denied reopening the case and they've been overturned. And in fact, if you look at the cases that we cited in our briefs, it's pretty consistent that that point in time where the jury begins deliberation, the courts take a really different view of reopening the case than if it happens beforehand. You know, in the Larson matter, they talked about the fact that...
But
hey,
this is an extraordinary allegation if prison officials are soliciting witnesses for the prosecution. That calls for extraordinary measures, doesn't it?
Oh, I think you need to flesh that out, absolutely, because that would be very damning. But clearly, after all the evidence was flushed out through translators, it didn't amount to a hill of beans. I mean, it wasn't there. And I think that's the important aspect. And, you know, when the defendant wants to say it wouldn't have taken 60 days, well, I asked that very question in the first couple hearings. I'm like, show me the actual recorded call that you're speaking of that you alleged back on that date in front of Judge Davis when you asked us to suspend the deliberations for 2 days. I said, give me that phone call. They never could do that. And I think that's compelling and also indicative of the fact that it would have taken 60 days because they weren't able to tell us specifically this call is the one, the golden nugget that's going to basically turn this case on its head. And so that's why I think that 60-day analysis is appropriate. I think it's also compelling that this court can look at the fact that after he was found guilty, Mr. Horton was found guilty, there was 4 months before the motion for new trial. 4 months that they could have vetted that out and in their motion for new trial submitted that evidence for the court's consideration. That didn't happen then either. So there were plenty and ample opportunities for the defendant to vet this out to the district court to allow them to make the proper analysis back then, and they chose not to. And I think it's because it didn't exist. If you look at the evidence itself and apply the Murdoch analysis, what you see is, first of all, the timeliness of the motion. The court did not say that the defendant did anything wrong or his counsel in submitting this information at the last minute. It was by virtue of basically how long it took for them to get it.
Well, let's kind of talk about that for a second, because here you are opposing the allowing of this evidence, albeit at a late date. But weren't you the cause of that to happen? I mean, you didn't disclose the information to the defense until shortly before trial, as I recall. Defense had no knowledge of this information about the conversations until shortly before trial. Turned over the discs that contained the information, the
You talking about
conversations.
prison phone calls?
Yeah,
That wasn't something that we had requested at all, Judge. Basically,
I thought that was in your possession. You turned it over to
no, that was a subpoena done by the defense for those phone calls. That wasn't something that we asked for. That was something that the defense had requested through their own subpoena powers, and that was something they acquired. So that wasn't something that the state held and then last minute turned that over at all. Because I think if that had happened, I think you would have heard a lot more discussion at that point between the defense and the state. Because if you recall, Judge Davis says, are you saying that the state did anything wrong in that hearing when we were, while the jury was deliberating, and the defense said, no, we're not alleging the state did anything wrong in this whatsoever. So in that regard, it was a subpoena issued by the defense to obtain that information. The other thing that I think is really compelling, one of the factors in Murdoch that a lot of courts have ruled on is the effect of granting the defendant's request. In this case, you have a jury deliberating, and then you're having to suspend the deliberations. And then you've got the issues of, okay, if you present this new evidence, how are you going to instruct the jury so they don't place more significance on this than the other evidence that was presented at the time of the trial? Secondly, how are you going to instruct the jury? Third, are the parties going to be able to have any kind of closing arguments to address this new evidence? Because if you're reopening the case, then do you allow the parties to have closing arguments to be able to comment on that? And so it creates a whole set of problems that the court would have to review and determine. And we looked, and we are not aware of any case in the state of Kansas where we've ever allowed a case to be reopened after jury deliberations of this nature. And so I think the court looked at that, at the effect, and determined that that was one of the main criteria for his denial of the motion was, how do you do this? I mean, think about this, because it would work for both sides. You know what? The jury's been out for 8 hours. I'm going to go ahead and ask to reopen my evidence and put some more evidence on. I mean, so is the state going to be allowed to do that? I mean, so it would be opening a Pandora's box, I think, to say, once the jury's deliberating, we can just reopen things. And I think it would really create problems for our judicial system and being able to affect justice by doing that. And I think that's why if you look at the court's analysis and the cases we cited, they talk about that really there has to be some extremely substantial evidence and reasons to go ahead and reopen a case in any question, especially when you have a jury starting its deliberation. And if you look at the cases that we cited, even before the jury's deliberating, the court takes a very dim view of just reopening the case at a person's whim, and they have to show good cause. And in those cases, like Larson, the jury was breaking for lunch. They were going to start out their jury instructions and do closing arguments. They wanted to reopen the case. The court said basically, well, that's not going to create any problems for us. We'll go ahead and reopen the case. That's the type of thing that I think is permissible, and it allows for discretion of the district courts to occur. But when you get to the point where you've already done closing arguments and the jury's deliberating, I think that really has an impact on our ability to affect justice for both sides. And so by looking at that again, there's absolutely no case law to support the defendant's contention that this would be appropriate. The court made its proper findings that in this case and the last factor being that, really the evidence, and, Justice Rosen, you cited this, it's really cumulative evidence that something that the defendant already presented. He had 3 witnesses that attacked the credibility of Mr. Castillo-Contreras. So that evidence would have been cumulative. You also have a discussion by the defense that, he was trying to cut a deal. Well, the letter to the Colorado Parole Board was admitted into evidence for the jury's consideration. And really the only thing that the phone calls elicit is that he's trying to negotiate. And that's really all that says, is he wants some kind of deal. Well, he got a letter, and that letter was admitted, and the jury was able to use that as part of its deliberations. So that's nothing new. So all they're asking for is cumulative evidence on the character impeachment of one of the witnesses for the state. And that's what it all boils down to. And I think it's also interesting in that the evidence that they cite in their brief that is so compelling was not the original reasons why they asked Judge Davis to suspend the deliberations. If you notice, there's two different areas that they addressed in that. The first one was that someone was coaching Mr. Castillo Contreras, and that there was somebody trying to talk to him, and that Barnhouse had some lack of credibility, the other prison inmate who testified. That was the original analysis that they talked to Judge Davis about and asked him to suspend the deliberations. But if you look at what happened once we got back to the district court, when you remanded this back, it was a change of tactics. No longer were those the criteria that they were looking at, but now with all the translations, they used this additional information that wasn't in the original proposal. And that is basically that Castillo Contreras wanted a better deal, was really the basis of it, or trying to orchestrate a better deal. And so, one of the things that we cited in our brief was that really wasn't the original criteria that they submitted to the district court or they proposed to you in the original briefs. And should we even weigh or consider this additional evidence that came out as part of the translation? It now is the crux behind their entire arguments. We would argue that it's new and it's not part of the original briefing that they made to this court. But even if you did consider it, we find that the evidence that was presented has minimal effect, and as the court indicated, would not have changed his mind whatsoever in making his decision to deny their request to reopen the matter. So for those variety of reasons, we're going to ask that this court find that the defendant's substantial rights were not hindered as a result of this, that there was no prejudice that was attached, that the court made the proper findings, maybe based on the wrong analysis, but the court made the proper decision, which is I'm not going to reopen the case. And even after presenting everything that the defendant could, in light of all the translations and time and effort that they put in, the court found that it did not amount to sufficient evidence for this court to reopen it or change its mind and find that it committed error. So I would ask that this court deny the defendant's request to find that there was reversible error and prejudice and a request for a new trial.
If we disagree, do you agree with counsel that you waived harmlessness by not briefing it specifically?
I don't think so, chiefly because the statute says you have to consider that analysis in all cases. And secondly, you remanded it back for us to make a specific finding, and that's what we did. And I think at the district court level, absolutely, the district court, their analysis was, did I commit error or was there grounds for me to reopen the case? Your analysis is a little bit different. I think by statute, you still have the ability to make the decision whether or not there were substantial rights prejudiced in this case. That was your request, is to find out facts to make that argument. And I think that the mere fact that we didn't put anything in the brief doesn't prevent you from making that analysis.
So you would read 6261's direction that the court has to disregard any error that doesn't affect the substantial rights as being an affirmative obligation on the court.
Yes.
And so what happens with our case law regarding the burden on harmlessness?
On the burden of?
On harmless error, the burden on the party that benefits from the error to show that it was harmless.
Well, I think we did that in our brief. I think by using the Murdoch factors and the analysis the court made and what we did in our brief, I think we put those arguments before this court.
But it wasn't
That's-
error.
Yeah,
I
the
mean,
Murdoch, sorry, go ahead.
I'm sorry.
that has to do with whether there was error or not whether it was harmless error. That's what she's trying to ask you about.
I see your point. I think you could use the same factors that we cited in our brief and our analysis to also find that it's harmless error, in addition to there was no error by the district court. I think they're
The
one in
idea
the
that it
same.
was cumulative, that sort of thing.
Yes, I think they're one in the same,
In
the
this
same
case.
type of analysis.
Any further questions of counsel? Thank you, counsel.
Thank you for your time.
You have 3 minutes for rebuttal.
Thank you, Your Honor. I would just like to address the state's argument that this court shouldn't consider these arguments that Mr. Horton has advanced essentially for the first time on appeal. The whole reason that Mr. Horton wasn't able to cite to the conversation originally is because the district court denied defense counsel's request to give it 2 days so that it could review the transcripts. So it didn't cite them because it couldn't cite them. It didn't have that information at the time, and the district court shouldn't now be able to use its error to shield it from this court's review of that error on appeal. Unless the court has further questions, that was the only point I wish to make on.
I had a question. Opposing counsel indicated that they had searched the world, or at least the nation, for case law that would precisely fit this scenario, and they were not able to find it. So I'll simply ask you, what do you consider your best case supporting your position?
Well, I think that Davis, which this court cited in its opinion remanding the case, is probably the closest factually in terms that the parties had already presented all of their evidence and the jury had been instructed that there would be no further evidence. And it's not really clear in Davis from the facts set forth in the opinion whether they had started deliberation or not, but certainly the evidence had been closed. It sounds possible from that case that it had gone to the jury. They had gone to lunch, and over the lunch break, defense counsel had stated that they wished to present additional evidence, and then this court did find that the district court abused its discretion in refusing to reopen evidence.
Do you have a position on some of the questions that counsel posed, such as assume you do this? Do you have supplemental closing arguments? Do you give some sort of a limiting instruction to the jury so that the jury does not put undue emphasis upon this new evidence? Are they owed any kind of an explanation as to why this kind of out of the ordinary measures being taken? Do you have any response to those sorts of questions?
Absolutely. I think a limiting instruction would have been appropriate, and I addressed that in my brief, that's something we give juries limiting instructions all the time, and we presume that juries follow those instructions, so we tell them to disregard evidence all the time, so I don't see any problem in telling them not to give evidence additional weight. If we can believe that a jury can simply disregard evidence that it's heard, it seems we can also assume that they can give no more weight than they ought to evidence based on its timing. The administrative concerns, I understand, are problematic, but yes, I think it would have been in the discretion of the district court then to allow the parties to give additional closing arguments. That's something that the parties could have worked out below. And I really think that administrative concerns like that can't overcome a defendant's right to a fair trial, which is what was violated here. And yes, it would have been inconvenient and problematic, but that evidence needed to come in, and that's the bottom line.
All right, thank you.
Thank you.
Do we have any further questions? Thank you, counsel.
Thank you, Your Honor.
Thank you both for your arguments this morning. Court will take this matter under advisement.